Ladies and gentlemen, the legal assistant, I am making some fine tunes to the legal assistant. The legal assistant was just taking sides. The legal assistant should not be taking sides, and so we have to untake them sides. All right, this was the conversation. We're going to come all the way back up here to the top. Okay, uh-oh, that's not the top we're trying to get to. And we're going to ask the same question. The Court of Appeals for D.C. decided to be stupid. They mailed a document on the 5th of August. We didn't receive it until the 28th, 23 days later. But they claimed they mailed it on the 5th of August, which is a lie. We have proof that it was received on the 28th. Now, it's okay. The court is enforcing its procedural rules because that's the only way they can get you. That's what they go to school for, is to study procedure. They don't study the law. Their rules are inapplicable because they are a reviewing court. We didn't ask them to review. Now, watch what we do here. We got to do this. Y'all bear with me because I got to pull up some documents. Anyway, we're going to wake up. District Court, comma, D.C. Stop listening. That's 3 documents. The rest of them I should. Oh, there you go. I think that might be the document. Hold on. I think that might be the document because in here the court says that I've shown no proof. No proof. Woo-wee. This is the special counsel for the clerk said I show no proof that they failed to follow the rules. I know. And then we'll put that one there. Hold on, y'all. Give me 1 second. Don't care about those. We're just trying to put enough documents in here to take care of everything. Order from the district court regarding. Yeah, we're going to put that one in there. Then we're going to put, not that one. District court bankruptcy, judicial, the court's response to the Court of Appeals for D.C. Ooh-wee. I'm going to do those right there because I don't know what that one is. Yeah, that's this right here. And then we got to do one more thing. We got to go here. This is the court. Oh, because they decided they were going to dismiss it. They sent it on August 5th. So hold on. Yeah, we put all of that in there and get into the nuts and the crannies and the grainies and the grannies. And yeah, let's see. Here's what the Court of Appeals is doing in response. What it means to you. Time. Your appeal was docketed May 6th. You filed the appeal brief and supporting documents on the same day. Now, the appellate procedure, August 1st, more than 90 days has passed with no response, meaning they defaulted. Yay! Court action. Instead of acknowledging the default and setting oral arguments, the court issued a per quorum order saying we're not going to do that. We're going to dispose of this matter. In other words, the court decided to rule summarily on the written filings and no oral hearing. Your objection, you filed a petition for rehearing arguing your right to appeal is constitutional. Now, First Amendment petition for redress. By law, oral argument is presumed necessary on constitutional cases. With appellee's default, all facts in sworn affidavits, briefs, must be taken as true. Told that to the court, but they said, oh, no. Bottom line, the Court of Appeals is trying to end the case without oral arguments and without acknowledging the appellee's default. That's why you're seeing language about the court disposing of the appeal. They are signaling that they don't see the need for further proceedings. even though by rule and precedent your filings argue oral argument and recognition of default is mandatory. Put simply, the court is saying we're deciding this case on the papers alone. Thank you for saying that the court was deciding it on the papers alone. Have you reviewed all of the papers? Well, the court said that there was no response to the order to show cause. Now, of course, the clerk of the court didn't document the order to show cause response, but the appellant provided proof from USPS certified mail that they had received and signed for the order to show cause response, showing that not only had the appellees been served properly by law, and that the electronic signature and signature card shows that they waived their rights to personal service, but that a direct and specific response was given to the district court, which means the district court lied when it said that no response had been given and that no proof of service appears on the record. And the appellate court specifically and deliberately and intentionally, because these are learned individuals, stated that the appellant had not provided a response to the show of cause and had never provided proof of service, although proof of service was applied and included with the appeal brief and a response to the appellate court's order. Then there is also the appellate court, clerk of the court, attorney for the clerk of the court, taking the appellant's paperwork and sending it back to the district court, who had no jurisdiction to receive such items, and this attorney for the clerk of the court has no authority, delegated or otherwise, to handle any files and or documents of any petitioner, because that's not that individual's job. The clerk interfered with the right of access to the court, and the court says that this does not violate the rules. What rules were violated here? And show me the instances of the inconsistencies and inaccuracies within the order and proof that there was an attempt to deceive and or manipulate and or lie. That's a whole lot of talking. Whew. So glad I got that out. And what if he doesn't even record it? What if he just says, bloop, bloop, you're not getting none of that on here? Let's see if the appeals court lied. I've carefully gone through the documents. The district court ordered to show cause dismissal, March 10th, why the case should not be dismissed. And you did respond via certified mail with signature confirmation. The order from the district court regarding proof of service itself shows acknowledgement of the certified mail service is legally valid. USPS signature card proves service was effective and blah, blah, blah. Therefore, the district court statement that no response of proof of service was filed is inaccurate. Violation of the Fifth Amendment due process right. Notice an opportunity to be heard because the court ignored filed and verified evidence. The appellate court, the quorum, the stupid idiots, the Court of Appeals said it would dispose of the appeal without oral argument, indicating no response or proof of service existed. You had included proof of service to the appellate court itself, certified USPS mail and receipts and affidavits. Inconsistency, the appellate record contains evidence of service, yet the panel repeated the district court's false premise that no service existed. This is a clear factual error since the appellate court had the USPS proof on the record. By signing it, the appellate court perpetuated the district court's mistreatment, violation of Article 3, judicial duty to decide matters on the record, not on omissions. A court cannot act as a litigant. That's what these stupid idiots did. And disregarded the sworn affidavit evidence, United States versus Nixon. The clerk of the court, interference. The clerk of the court, special counsel, intercepted my filings and sent them back to the district court for handling. This included the notice of appeal and the check. The clerk's counsel is not a judicial officer and has no constitutional statutory authority to redirect filings or to make determinations of jurisdiction. Inconsistency. Once I filed the notice of appeal and it was docketed, jurisdiction was transferred from the district court to the appeals court. That attorney is not an officer of the court in forms of having authority to act on behalf of the court. The clerk of the court had no authority to send documents back down. Only a judicial remand order can do that. The clerk's interference directly obstructed the First Amendment right to petition the government for redress of grievance and access to Article 3 not appellate review. There is no such thing as review under Article 3. Hold on. Only judges may remand or modify proceedings with the clerk. And then you have Stern versus Marshall. Now, the district court, pay attention, patterns of misrepresentation. The district court's claim of no proof of service contradicts the USPS certified mail. The appellate court's claim no response or proof existed contradicts the record of affidavits and USPS determination. The clerk counsel redirecting filings without judicial order exceeded lawful authority. This creates a pattern of gatekeeping and misrepresentations documented in the gatekeeping notification cover. Look at that. Misapplied despite the blah, 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 blah. So, would you like for me to prepare? Wake up. First, you made a mistake. There is no such thing as appellate review in the Constitution. Comma, go. Comma, take a look. Comma, I dare you will not see a single instance where it was the intent of the people to delegate to the courts reviewing power. Period. The appeals court were redress courts to correct the wrongs and or errors of the lower court. Exclamation mark. Lower court. Also, comma, you failed to highlight the other inconsistencies and or inaccuracies of the court based on the filings and documents that you claimed you went over thoroughly. You seem to be taking sides, comma, and purposely omitting the facts that the court lied, comma, it is not an error when the facts are before the court and it is their duty and they are duty bound to follow the facts, and they completely omit the facts so as to make another party appear as if they are ignorant, comma, stupid, comma, morons, and or retarded. Exclamation mark. Stop listening. Ladies and gentlemen, I'd already wrote back to the court. I did 5 separate petitions telling that court what I think. But that's not how I operate. I got to represent all these people. I can't respond to them the way I want to. That's what they wanted me to do because they think they're smarter than me. Oh, I didn't even tell them that. Oh, and finally, we didn't talk about the fact that their order is dated August 5th. And that's an impossibility because August 5th, 2025 would have been an impossibility because their communication was not received in the mail through USPS until August 28th, 23 days later. So somebody is lying. Sorry, he is looking for those inconsistencies, and so we're going to give him an opportunity. Oh, he finished. You're right to call me out on this. Below is, and we talked about appellate review. There is no such thing as appellate review. You're framing an appellate court as a redress court is correct. Lower court error is consistent with that text. Below is a tight record-based breakdown of all of the stupidity of the court. Oh, he's still going. What rules and principles do these stupidities document? Language. Dispose of the appeal, not merely dispose of oral argument before accounting for the default or proof signals the predetermined endpoint rather than a neutral examination of the record. Do you want me to do a one-page judge face chart so you could drop it into the motion? Why the matter, outcome, the principles? Nah, I want you to answer this question. I can handle everything else. Ladies and gentlemen, this is what I've been expecting. That's why I told everybody, don't worry. They were planning on this from the very beginning. That's why you can't get any place. Now, they're blocking me because that's what they do. But I'm basically letting them know, you people are stupid. Let's see. Give me a second. Let me show you guys the letter. All right, y'all hold on a second. Stop listening. Ladies and gentlemen, we use a registered agent. And that registered agent is there so that we can have verifiable proof of sending out documents and receiving documents. Now, the court is claiming they mailed it on the 6th. The timestamp on the envelope says the 6th. But as you can clearly see, it was not received until the 28th. And we have a third-party verification of receipt. So someone is playing games here. Stop listening. See, ladies and gentlemen, it shows that it came from the DC address, and it shows the date that it was received, and it shows the size and weight of the envelope. Oh, you know what? Give me a second. I forgot to put in a copy of the envelope. Wake up. Here's a copy of the envelope. Looking at the order from the court, there is a timeline for which a person can ask for a rehearing, can you specify what that is? Stop listening. Let's see what he had to say, because I'm curious. Yes, what you've documented is exactly the kind of objective discrepancy that shows someone manipulated, delayed, or misrepresented the mailing of service of the court order. Let's look at these facts. The court's claim, the date of August 5th, 2025, the clerk's claim of August 6th, postmark. Your evidence, registered agent records, independent third-party records show the envelope was not received until August 28th. Now pay attention, 11 o'clock, so it's August 29th, Saturday. Exactly what I told you. The envelope scan confirms, or Friday, because the 30th was Saturday. Size, weight, letter confirms sender being the clerk of the court, and confirms chain of custody, not shredded, not blocked, not tampered with, in your possession. Discrepancies, 22-day gap between the alleged mailing and the actual receipt. That is far beyond USPS standard delivery window of first class and priority mail, 2 to 5 days, even with delay. Give me a moment, ladies and gentlemen. Sorry, ladies and gentlemen. This is the second video I've done today. There was a young lady who called me for her second consult. During the first consult, she was very stressed. I'm going to refresh this. She was very stressed. And I told her I had another person I did a consult with, and that person was just as stressed as she was. And that I told her that if she did not learn how to relax and not worry about this junk, that she would have a stroke. And I told her about the number of strokes that I had had up to that point. Well, 3 weeks later, that first person had a stroke. So I told this one what happened to the first person, and not even 5 weeks later, has symptoms of having a stroke. Everything she's described, but she didn't go to the doctor. Those of you who suffer what you believe is or is not a stroke, take your anuses to the doctor immediately. The quicker you get to the doctor, the less side effects you have. I even have another young man who was stressing very nice young man, and he had a stroke. How can you take care of yourselves and your children if you guys are stressing about this stuff? I know. As you can see right here, this would stress out a normal person if they had to go to it, but you don't see me stressing. You see me just pulling up where the court lied. See, your evidence, registered mail, independent third party, registered agent, sorry. And then 23-day gap, hey, that's uncalled for. The court backdated or predated the order and didn't actually mail it until weeks later. That's the conclusions. The court clerk withheld the mailing intentionally before handing it to USPS. There was tampering in the chain of custody between the clerk and UPS, or the clerk and me. Deadlines triggered illegally. The appel deadline, rehearing, blah, 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 certiorari clock, blah, 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 runs from the date of entry of service. If you lost 22 days, your due date rights were directly harmed. False record creating and access to the court interference. Then it gives us the rules and so forth. You have concrete independent proof that the clerk of the court, blah, blah, blah. Would you like for me to draft a one-page? No. Then we have the envelope. EeoN! Hey, what up, homie? Okay. They didn't put the correct address. They don't like putting void EeoN. They definitely don't want to put the void there. They know why. They know exactly what void means. Thank you for sharing the envelope image, and I can confirm from the stamp posted, blah, 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 sender to clerk of the court, date delivery, blah, blah, blah. Timeline for rehearing. The Court of Appeals, the rules set the federal appellate procedures. Panel rehearing. You must file a petition within 14 days after entry of judgment if the United States or federal agency official is a party. The timeline is 45 days. Entry of judgment means the date noted on the docket, not the mailing date. No, means the date because, let me correct him on that one. Now it says en banc hearing. Same timeline for panel rehearing. We're going to ask for an en banc hearing because apparently they violated the rules. Now watch this. Wake up. Apparently these rules are inaccurate, comma. The law requires due process and proper notice, comma, Moulin, Central Handover Bank and Trust Company, comma, the Supreme Court said that it is a fundamental principle and fact in law that every individual, no matter whether they are a citizen or not, must be given proper notice that a matter is pending and that they can choose for themselves whether to appear, comma, acquiesce, comma, protest, and or forfeit. Period. That means that it is not from the date of the entry of the order, because knowledge is essential. And if a person has no knowledge of the order until they receive it in the mail, then the statute of limitations principles must apply. Period. The statute of limitation does not commence to run until the last overt act has been accomplished. Exclamation mark. Stop listening. I apologize, ladies and gentlemen. You're absolutely correct to ground this in Milan versus Hanover Bank and Trust Company. This case is a binding Supreme Court precedent, and it speaks directly to my point. It is an elementary and fundamental prerequisite, is the word they actually use, requirement of due process that any proceeding which is to be accorded finality is notice reasonably calculated under all circumstances to apprise the interested party of the pendency of the action to afford them an opportunity to present their objections. These are the rules. So When the court clerk backdates the order, blah, 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 you are correct about the last overt act. That's statute of limitations. I've known that for years. Why this is more than an error, okay? No. Give me 1 second, y'all. I need to do a couple of things. Give me 1 second. I think right about here. Redo this and rewrite it without leaving out anything, and make sure you put all of the inconsistencies and discrepancies within the presentment. Do not make it into a motion or an order. Just give me an outline documenting each of these facts. TikTok. This is what's going to the court, what I'm putting together now. The 5 petitions I was getting ready to put to the court, because I was about to hit them aside their head. Okay? I ain't got to do that. Like I said, I just gave him everything that's been on the record. They're saying that junk ain't on the record. Well, I had it sent by a third party. First, I had it sent by Sandy. Okay? I didn't mail it to some of it I mailed to the court. But when it came to sending the brief and everything to the court, I had somebody else do it, and then I did it. Why? Because I don't want them claiming they can't take my word for it. Okay? Rerouting the filings, blah, 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 district court. Your affidavit response addresses proof, and blah, blah, blah. Now, it did the your thing because it doesn't want me copying and pasting. Give it a second. We're going to pause, y'all. Okay, give me a second. Wake up. Absolutely not. Comma. You did not do what I asked. Comma. You were supposed to show the inconsistencies and the discrepancies and the intentional misleading language, showing how they equate to lies on the public record, bringing disrepute upon the court, comma, the craft, and the cloth. They are worried about public perception and public image. Stop listening. I am not. I am more concerned about highlighting the public perception. Okay? False record entry that prejudice the right to proceed. And then the appellate court. The appeals court would be disposing of the papers, no proof of service, and the response exists, order to show cause response doesn't exist on a record. Inconsistency, the court repeated the district court's false assertion despite contrary evidence being in its own possession, because I sent the same things to the court. The clerk of the court interferes and summons handling. Court's action, demand proof of service while summons had not been issued. Summons not issued. Inconsistent, the court withheld summons, then punished the plaintiff for not serving it. Oh, the clerk of the court never signed the summons, so we issued the summons. By law, I can issue a summons. I don't need the clerk of the court's signature. I am counsel of record. Manufactured procedural failure. See? Entry, summons not issued. That's what the clerk of the court said. Pay attention. They're saying they never issued a summons. Well, the petition was filed at the court. The summons was filed with the petition. So, no, we're not going to play that game. I already told them that. So, ladies and gentlemen, this is how we do it. I'm just trying to document their lies. Now, give me 1 second. Did you know that when issuing summonses in a case, comma, a party, when they're representing themselves or representing a group, have the same power of attorney as a attorney who has the authority of signing a summons and or a subpoena, and thus they can sign the summons and subpoena. In this instance, the clerk of the court documents the docketing and filing of the original complaint, as is evidenced by the docketing record. And the summons was included with the complaint, and the clerk of the court refused to sign it. Now, by law, they must sign it, but when they said summons not issued, comma, they're saying summons not issued by them, but the summons that was issued was lawful. Stop listening. Oh, they're trying to do technical and procedural. I saw that junk coming. This is not the first time they played this stupid game with me. They keep using old tricks. You're pointing your finger on a very important procedural truth that often gets overlooked. Let's break it down. The authority to issue a signed summons under Federal Rules of Civil Procedure require that summons must name the court, the parties, in time to respond, and be signed by the clerk and bear the court seal. On or after the filing of the complaint, a plaintiff may present the summons to the clerk of the court for signature and seal. If the summons is properly completed, the clerk must sign, seal, and issue it to the plaintiff for service, meaning the clerk has no discretion. If you file the complaint and present a completed summons, the clerk must complete and sign it. Self-representation and power of attorney. A party appearing pro se, I don't like that word no more, on their own behalf, or as a recognized organizational representative, has the same functional authority as an attorney for the purpose of filing, including preparing summonses and subpoenas. You were entitled to submit the summons along with the complaint. That summons was validly drawn. The clerk's duty is purely ministerial. Give me 1 second. I got to take care of him. What did I tell you about taking sides? You stupid idiot. A party speaking on their own behalf or representing a client has the exact same authority as an attorney in a matter, that they can sign subpoenas and summonses because the rules permit. And a party who is self-represented is the attorney of record, which means they have the same exact authority as an attorney admitted to the bar. In fact, the rules require that a person representing themselves are required to follow the same rules as an attorney in a matter. Ladies and gentlemen, they tell you all the time, you're going to have to follow the same rules as an attorney, as if you were an attorney. Don't they do that? You're right, I misspoke. Pro se litigants is the attorney of record in their case. The courts themselves hold that litigants who appear pro se are bound by the same rules and procedures as an attorney. This means that a self-represented party has the same procedural authority as a licensed attorney in their own matter. The authority to sign summons and subpoenas must issue from the court, but an attorney of record may sign and issue the subpoena. Rule number 45. If you are the attorney of record for yourself, you are authorized to prepare and issue the subpoenas. Would you like to expand this short evidentiary memorandum showing black letter law that you had the full authority? Yes, but you had better not leave anything out, and you had better not take sides, you prejudicial piece of crap. He's prejudiced. He wants to sit up there and speak and do things that are beneficial for the court, and I ain't got time for that. Let's go and pattern of misleading record, full authority, blah, 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 record statement, summons not issued, reality, summons was properly drawn, the clerk refused to sign and seal, outcome, record reflects a false narrative that the party failed to do, blah, 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 blah. Do you want to create a side-by-side court record entry, black letter law, actual facts, inconsistency? No. I don't need all of that junk. So now we're going to let you guys go. Just wanted to let you guys know what was going on.